Today's presentation, reviewing your New York anti-harassment policies, will get started in a few minutes. Just want to give everyone a chance to get logged in to be able to participate in today's session. So as you are joining, hopefully you are able to hear me and see the slide, the cover slide reviewing your New York anti-harassment policies on your screen. You should also have access to a chat window. If you have all of that, then you should be good to go, and we will get started in a few minutes once everyone has had a chance to get logged in. Looks like people are still getting logged in, so everything seems to be working fine in that regard. And on my end, again, if you can hear me and see the cover slide reviewing your New York anti-harassment policies, then you are ready to go, and we will get started as scheduled in a few more minutes. All right, we will get started in about 2 more minutes. It looks like everyone is able to get logged in, so I just want to give everyone a chance to do that right up to the scheduled start time, and then we will get going. Thanks for all of you joining today for today's presentation on reviewing your New York anti-harassment policies. I am Scott Horton. I am a partner now with the Gunnar Cook Law Firm. I also operate a blog at hortonpllc.com, which you can review for up-to-date information on labor and employment law developments, especially applicable to New York workplaces. Today's presentation will last about an hour. Included in that will be a question and answer that I will do at the end of the presentation. If you have any questions throughout the presentation, please type those in chat. If I happen to see one and an opportunity to answer it in the course of the presentation, I'll go ahead and do so, but I will generally answer the questions at the end. but I want you to go ahead and get them in when you have them so that you don't forget your question and that we can review them to make sure that we get a chance to answer them. Typically, we'll try to stay on until all the questions have been answered, and that may run us a little past an hour. Obviously, we try to keep timely, but want to make sure you get the information you're looking for. If you need the HRCI credits, you will be eligible for an hour if you attend the entire webinar today. You will get an email tomorrow if you are attending that gives you the approval code for that credit, and you'll also receive in an email the materials, the slides, that is, for today's presentation. But if you do want those sooner, I will make them available to you to download at the end of today's webinar. With that being said, I'm going to jump into our topic, starting with a little bit of background on the anti-harassment laws that may prompt you to have the policies that we're going to talk about in more detail. So at the federal level across the United States, employers are subject to Title VII, which prohibits discrimination, including harassment based on race, sex, color, religion, and national origin. The Americans with Disabilities Act covers disabled individuals and prevents discrimination, including harassment based on disability status, including perceived disabilities or being regarded as having a disability. The Age Discrimination and Employment Act is another federal statute that prohibits age discrimination, and again, that includes harassment based on age. The federal law there is limited to protecting individuals who are 40 years old or older. The Genetic Information Non-Discrimination Act is the newest of these federal statutes that prohibit discrimination based on genetic information. Genetic information, however, is broadly defined to essentially include a wide range of medical history about an employee's family. So there is more risk for discriminating or harassing someone based on genetic information than may seem obvious from the name. Doesn't necessarily mean they're being targeted based on the results of genetic testing. For example, if someone is harassed based on their family member's medical history, they might have a claim under GINA, the Genetic Information Non-Discrimination Act. With those being the primary anti-discrimination and anti-harassment laws at the federal level, New York State has its own employment discrimination protections found in the New York State Human Rights Law, which jointly addresses all of those other forms of discrimination in some way, shape, or form that are protected at the federal level. And then the New York City Human Rights Law applies within New York City. So if you do have employees working in New York City, it's quite possible that they have protections under the New York City Human Rights Law, the New York State Human Rights Law, and the federal statutes, which we'll get back to briefly later on to explain that will mean that those employees might have the right to go to as many as 3 different employment discrimination agencies if they have a complaint that they would like to make. Since we are focusing today on New York-based anti-harassment policies, I want to focus on the New York State and then to a lesser extent New York City laws. But again, your policies generally would be written in a way that would recognize that there are federal laws that may be applicable as well. New York State has a broader list of protected categories than the federal statute collectively do. Here, note that age is not limited to individuals 40 years or older. It includes anyone 18 or older and protects from discrimination and harassment based on age in both directions, meaning not only protecting someone from being discriminated against in favor of younger employees or applicants, but also prohibiting harassment based on someone being, for example, too young for a position. Again, with 18 being the minimum cutoff. The other protected characteristics show a good degree of overlap with the federal statutes, but go on to include additional specific items such as gender identity and expression, citizenship, immigration status, military status, familial status, marital status, and the status of being a victim of domestic violence. We're not going to get into too much detail on what all of these actually cover in their complete scope, but the point being that New York State protects more characteristics than the federal laws do. The only possible limitation on that is, I mentioned GINA, the Genetic Information Non-Discrimination Act. Its definition of genetic information is probably broader than New York's definition for predisposing genetic characteristics. So that is one area where the federal law may actually offer broader protections. When we switch to the New York City protected characteristics, we're going to see that they're very similar in many respects to New York State's law, but there are some additional categories specifically identified in New York City, such as credit history and salary history and unemployment status, for example. Coming up later this year, the New York City human rights law will also be amended to include protections based on height and weight. So that is a New York City development that is expected to happen later this year. Often New York State follows what New York City does, so it would not surprise me if sometime in the next year or so, New York State amends the human rights law to also prohibit discrimination and harassment based on height and weight. So that is something you may want to keep your eye on. A few years ago now, amendments that took effect in 2019 changed the New York State human rights law to make it easier to prove unlawful workplace harassment in New York State. So these amendments generally, as I mentioned before, is a trend borrowed from what New York City already had in place. Most significantly, the amendment eliminated the longstanding severe or pervasive standard that still applies under the federal employment discrimination statutes, and until 2019 applied under the New York State human rights law as well. That is, for something to qualify as unlawful harassment, the conduct either had to be severe or pervasive, if not both. That meaning isolated incidents that didn't reach a certain level of severity were not considered to constitute grounds for a claim under the human rights law. Now, the human rights law specifically defines as unlawful conduct that subjects an individual to inferior terms, conditions, or privileges of employment because of the individual's membership in one or more of these protected categories. The ones we just looked at 2 slides ago apply across New York State. The amendment now note that the failure to make a complaint is not determinative. Since we are going to be talking about policies throughout most of this, discussion today. This is an important note that previously, before 2019, the New York State human rights law, like the federal statutes, allowed for employers to make a defense against harassment claims if they had policies in place that identified procedures to try to correct harassment that occurs in the workplace, whereby basically the defense was available that if someone had failed to take advantage of internal reporting complaint procedures, then they may be precluded from making a legal claim of harassment against the employer. Here, it's pretty clear that the amendments from the New York State Legislature a few years ago have eliminated that defense in New York State. So legally, it doesn't matter what your policy said or whether you followed it or whether the employee made a complaint in the first place. If harassment occurs in violation of the new standards under the New York State human rights law, then an employer can be found liable for it. One further specific note from the amendments is that employees do not need to demonstrate the existence of an individual to whom the employee's treatment must be compared. It's not clear that that was specifically required before, but just to be sure, the legislature has added that. In other words, the fact that someone is subject to a certain form of treatment or conduct doesn't mean that they need to show that there was someone else of a different protected characteristic or not having the same characteristics that they have that was not subjected to the same type of conduct. Ultimately, what the amendments do is lower the threshold for proving unlawful employment-based harassment to the level where the employer would have to make this affirmative defense. Affirmative defense is a legal term that says the employer would have the burden of proving this rather than the employee having the burden of proving the opposite. But the employer's affirmative defense now is that the harassing conduct does not rise above the level of what a reasonable victim of discrimination with the same protected characteristic would consider petty slights or trivial inconveniences. Again, this petty slights or trivial inconvenience language is borrowed from the New York City human rights law. That's where it originated. And it is clearly a much lower standard than the severe or pervasive standard that pre-existed the amendments. It is interesting that the standard is based on a hypothetical reasonable victim of discrimination with the same protected characteristics. Previously, the courts under the federal statutes and the state law generally imposed a reasonable person standard that would have basically made it based on what a reasonable person would have felt under the circumstances. So again, clearly the wording here in connection with everything else that was on the previous slide was intended to and effectively has lowered the bar for what crosses over from being unpleasant workplace conduct to illegal harassment. So now we're gonna turn to the policy issue. We know now that the legal standard is lower across New York State than it used to be, lower than it is throughout most of the rest of the United States. And we have historically used these anti-harassment policies to provide a potential defense that no longer exists in New York. All that being said, we also around the same time, a little earlier, have New York State coming in and requiring all employers in the state to have written sexual harassment policies and provide annual sexual harassment training to all employees. to be clear, the statute that took effect in 2018 and remains in effect today does not expressly require any policy or training on any of the other protected characteristics upon which employees would have the right under New York state law to claim harassment. So we will first address what the sexual harassment policy requirements are, and then talk about the other protected characteristics and what you should be doing and or must be doing in the way of policies related to those. So now what the law does and what the Department of Labor as a result of the law has done is identify specific elements that must be included in every New York State employer's sexual harassment prevention policy. The first of these requirements is that the policy must prohibit sexual harassment consistent with guidance issued by the Department of Labor in consultation with the Division of Human Rights. So the requirement to have the sexual harassment policy is based on the New York labor law, is an amendment to the New York labor law, but the actual prohibition of sexual harassment is in the human rights law, and those two different areas of law are governed by separate government agencies. So for whatever reason, this is what the state legislature decided to do, and as a result has required the Department of Labor and Division of Human Rights to work together in establishing the standards for these policies and the training that is also mandatory. What we don't entirely know is what this wording prohibit sexual harassment consistent with guidance issued by these agencies mean, because what these agencies have done is issued a model policy that we will be discussing, and it's not clear how much of that model policy, if any of it, is actually required to be in any particular employer's policy. When it says prohibit sexual harassment consistent with the guidance, does that mean that it just has to say that we prohibit sexual harassment, or does it mean that you have to say everything else that the Department of Labor and Division of Human Rights want you to say? What we further know is that your policy must provide examples of prohibited conduct that would constitute unlawful sexual harassment. Presumably, there are no specific examples that must be included or must be excluded, except that there are examples in the state's model policy. So does that previous slide mean that those examples need to be included? Best guess is probably not, but that is theoretically an open question. Your policy must include information concerning the federal and state statutory provisions concerning sexual harassment, the remedies available to victims of sexual harassment, and a statement that there may be applicable local laws. So if you are using the state's model policy or have based your sexual harassment policy based on those policies, you'll know that there's a whole section towards the end of the model policy that says this is what the New York State Human Rights Law does. This is what the laws administered by the Equal Employment Opportunity Commission at the federal level do. This is what might apply if you're in New York City, subject to the New York City Commission on Human Rights' jurisdiction. And they also recognize that there might be other local laws, and in certain situations, you may want to report the behavior to the local police. So that is generally understood to need to be addressed, but again, there's open question as to how much of the precise wording that is used by the Department of Labor in creating their model policy you have to include in your policy. And I'm going through this. Most of you have adopted your sexual harassment policy in response to the requirement that you do so a few years ago. But the main reason we are bringing this up now is that the Department of Labor and the New York Division of Human Rights have recently issued a new model policy. So we are building up to talking about what those changes to the model policy are and what that might mean for your policies. You're probably all aware that the state required that you include a complaint form for sexual harassment. Technically, you don't have to include that with your policy. There is guidance that says as long as your policy makes it clear where that form can be obtained, so you don't necessarily have to attach it to the policy. If you, for example, say you can go to Human Resources to fill out a complaint form, and then the complaint forms are available for employees to pick up there. But I think most companies have just included a complaint form with their policy, which is what the model policy has done. You have to include a procedure for the timely and confidential investigation of complaints that ensures due process for all parties. I think if you had pre-existing anti-harassment policies before the state required a sexual harassment policy, you likely had some sort of discussion about reporting this, and then once it's reported, it'll be investigated, and then the company will take appropriate action. So clearly that's required for the sexual harassment policies at this point. Again, the model policy has certain language that suggests how that investigation is going to be done. It seems unlikely that employers are required to adopt that language exactly and the procedure exactly how the state has suggested it. But again, there's not a whole lot of certainty as to how far you can deviate from that, recognizing that the statute itself does require that some due process be ensured. The policy has to inform employees of their rights of redress and available forums for adjudicating sexual harassment complaints administratively and judicially. So I mentioned before that the statute or the model policy identifies the various laws and agencies. So here is the other side to the law piece, that you have to not only identify which laws apply, but which agencies administer them and what employees can do if they want to go and file administrative complaints with one of the agencies or go into the courts. The policy must clearly state that sexual harassment is considered a form of employee misconduct and that sanctions will be enforced against individuals engaging in sexual harassment and against supervisory and managerial personnel who knowingly allow such behavior to continue. So this isn't really that shocking of a requirement. That certainly if someone engages in sexual harassment, that should not be acceptable. And a key point of the state's requirements are identification that supervisors and managers must be told, and other employees must be told, that those personnel must report any information that might be sexual harassment. And if they don't, that in and of itself is the grounds for discipline. The policy must clearly state that retaliation against individuals who complain of sexual harassment or who testify or assist in any investigation or proceeding involving sexual harassment is unlawful. Again, this is not really anything that novel or unusual. Someone who files a complaint of sexual harassment certainly has the right not to be retaliated against for filing that complaint. Okay, I want to just identify one other significant requirement related to the sexual harassment policy, and this has actually just been updated as well. in a certain sense. So your policy must be in the employee's primary language if New York State has model forms in the language. The written copy of information is going to refer to the training that's also required, and we'll get back to that. But so if New York State has a model sexual harassment prevention policy in one of these languages, then if you have any employees for which that's their primary language, even if they speak English fluently, you are legally expected to provide them a copy of your sexual harassment prevention policy in that other language. Now, this creates some complexity because, again, you're not required to use the state's model policy. That much is clear. Less certain how far you can deviate from it. But again, assuming you have your own independently created sexual harassment prevention policy, or you've modified the state's model sexual harassment prevention policy, and you have someone who, for example, has Chinese as their primary language, then you would also need to provide your policy to that person in Chinese. And that may mean you would have to translate your own policy because you couldn't just then rely on the state's model Chinese version of the policy, because it will then be different than your English policy. I said there was a slight update here. This list was shorter until recently, but in connection with updating the model policy, the state has required additional languages be covered. So in full now, there are model policies in Albanian, Bengali, Chinese, English, of course, French, Greek, Haitian, Creole, Hindi, Italian, Japanese, Korean, Polish, Russian, Spanish, Urdu, or Yiddish. So if you have any employee for whom one of those is their primary language, the law says you are required to give them a copy of your sexual harassment prevention policy in that language. Okay, so I alluded to this already. The statute that requires employers to have written sexual harassment policies and provide annual training says that the state, the Department of Labor, in consultation with the Division of Human Rights, must review their model requirements every 4 years. The law took effect in 2018, so the first review was due in 2022. And that was done, and a new policy was put out earlier this year in 2023. Again, as before, employers are clearly not required to use the model policy, but as I mentioned, it's not certain which guidelines exactly you have to follow. Whether the model policy, in other words, constitutes guidelines, and if so, to what extent. So that means there is some uncertainty over the impact of the new model policy. Arguments could range from you basically need to adopt it entirely to be compliant, to as long as you have otherwise met those basic criteria, whatever those might actually be, you may not even need to modify your existing policy as a result of the changed model policy. What we do know is that the model policy itself has a heading that says employers are encouraged to tailor this policy to their individual needs, though as a minimum standard, no section in this policy should be admitted. So that seems to maybe help give us further clarification of which guidelines need to be followed. But really all it says is no section in this policy should be admitted. Does that mean you have to have all of the same section titles? Does that mean everything in the section, therefore everything in the policy must be in your policy? There is not any degree of certainty, nor will the Department of Labor tell us exactly what they mean. So we are left doing the best we can to decide in any given case what to include or not include in your sexual harassment policies. Let's talk about what the changes to the model policy are. I mean, certainly there are plenty of words that were changed here and there throughout the policy, but for these purposes, we're going to assume that your word choice in most cases is not entirely critical. But here are some of the big substantive developments that have happened over the past 4 or 5 years. The new policy advises that sexual harassment need not be severe or pervasive to be illegal, and that intent is irrelevant. While when the original model policy came out, the amendment taking out the severe or pervasive standard had not yet been adopted. So that's understandable that they would change the legal or the identification of what is sexual harassment because the legal standard has changed. Stating that intent is irrelevant might go too far. The law itself doesn't say that. That is generally understood to more or less be accurate. However, there is some sense in which intent could be relevant. It could factor into what form of discipline gets imposed in a particular circumstance. And if it goes that far, could also factor into the scope of liability that the employer has. But I'm not going to get into all that at this point. Just that is language in the new model policy that would give me some pause. The model policy expands on issues of gender, gender identity, gender expression, as well as sexual orientation. There's pretty interesting language discussing gender as primarily tripartite identification. So that is obviously a different perspective than the historical male versus female separation. So there is specific wording in the model policy about cisgender, transgender, non-binary. Those terms specifically are used, and there's discussion as to what they mean that is new to the new model policy. There is an entire section, which is why I have that asterisk here, that incorporates bystander intervention methods. Basically, there's a list of things that it suggests bystanders may do when they perceive that sexual harassment is taking place. This includes potentially going up to the person engaging in the behavior and telling them to stop. The reason I put the asterisk is because where the previous language says at a minimum no section in this policy should be admitted, this is the one new component that I would say clearly is a new section. Therefore, if I was going to change my sexual harassment policy, I would probably at least include a section on bystander intervention. The model policy now addresses remote employees more directly in noting that sexual harassment can take place not only in person, but through video conferencing and the like. Obviously, this is driven by the rise in remote employment as a result of the COVID pandemic, which took place just after the policy requirement originally went into effect. There are also attempts to expand the sexual harassment policy to harassment and even discrimination based on other protected characteristics. I'm going to get back to that in a moment in more detail. A couple of other pieces that I think you probably should include in your policy are updates to the time for filing sexual harassment claims with the Division of Human Rights. Historically, you had to file claims with the Division of Human Rights in 1 year. That was amended specifically for sexual harassment claims since the original model policy was put into place. So now employees starting sometime in 2020 have up to 3 years to file with the Division of Human Rights. So your policy may state that incorrectly at this point if you haven't updated it. Real quick, to the extent the policy, as we're going to discuss, attempts to lump in other forms of harassment, I note that only sexual harassment allows claims to be filed for up to 3 years with the Division of Human Rights. Other forms of harassment still are subject to the 1 year filing period. So if your policy is going to also reference and include other forms of harassment in addition to sexual harassment, then you probably would want to make that distinction in the relevant section on filing administrative claims. The other note is that what I was just talking about is the time to file with the Division of Human Rights itself. Employees can file in court under the New York State human rights law, and if they go straight to court rather than going to the agency, then they have 3 years regardless of the basis for the claim. There's also a reference to a new hotline that was created because of a statutory amendment a year or so ago. And this hotline, 1-800-HARASS-3, is supposed to put potential claimants in direct contact with an experienced attorney who has a background in handling sexual harassment cases. I haven't heard any direct anecdotal information about how this is working, but I suspect that ultimately what is happening in most cases, or what would happen to the extent this is used, is that if someone calls this number and gets to speak with an attorney, the attorney is going to end up referring the person to filing a complaint with the Division of Human Rights. So I'm not sure how much different that is from filing with the Division of Human Rights in the first place, but they do get to speak to an attorney. The problem is the attorneys aren't paid, and the attorneys are prohibited from taking on the people who call as paying clients, even if the clients would like to enter into that arrangement. So I really don't see why the attorneys are going to have much incentive to do anything other than suggest that they file with the Division of Human Rights, where you don't need an attorney to proceed. All right, so what's this thing about the other forms of harassment being covered in the model sexual harassment prevention policy? So the policy does clearly try to lump in the other protected characteristics, including these two statements. Towards the beginning of the policy, it now says, while this policy is focused on sexual harassment and gender discrimination, the methods for reporting and investigating discrimination based on other protected identities are the same. In other words, we're spelling out investigation procedures in the sexual harassment policy because we have to, so we might as well let you know that we will follow these procedures if you report any other types of harassment as well. At the very end of the policy, which is 12 pages long, by the way, the policy concludes by saying the prevention policies outlined above should be considered applicable to all protected classes. I mentioned a minute ago that the filing period with the Division of Human Rights is different for sexual harassment and other types of discrimination and harassment claims. The model policy doesn't identify that, however, so that is one thing that I would be more careful about than the state apparently has been. If you're going to take this approach, clearly the legislature passed the law requiring a written policy on sexual harassment. Whether the state has the right now to require employers to put language in their sexual harassment policy addressing gender discrimination, even much less other forms of harassment and discrimination, certainly seems questionable. That being said, as we're about to switch to, certainly think it's a good idea to have policies that identify and prohibit the other forms of harassment. But again, that is a component of the model sexual harassment policy that I would question whether employers are really obligated to adopt. And really, more importantly, are there other ways of accomplishing the same thing? So what types of other policies may be under consideration in this area? So these are different terms that I'm going to use just to broadly identify different things, but some of these policies get lumped together, get referred to by different names, and the titles aren't all that critical. But one type of provision that many employee handbooks will include is an equal employment opportunity policy. This is a type of policy that says this company does not discriminate based on any characteristic protected by law, and therefore you should be free in all employment related decisions from discrimination on these bases. I mean, obviously I'm not reading from any specific language. There's no magic language that has to be included in that regard, but that's the gist of what I mean when I talk about an EEO policy. Again, there's no absolute obligation in most cases that employers have that. If you're a government contractor, then you might be obligated to have that type of policy, but as a best practice, most employers do make statements to that effect one way or another in their written policy materials with or without the specific EEO heading. Then there's a non-discrimination policy, which could basically be the same as the way I just described an equal employment opportunity policy, but certainly a different name that could be applied to such a policy. Again, generally making the point that we don't allow discrimination in our workplace based on any of the legally protected characteristics, which may then be listed out in detail or just several of them identified with some catch-all language about anything else that's prohibited by law. Then you have anti-harassment, meaning basically what we just talked about, mostly with the sexual harassment, but not necessarily limited to sexual harassment. In other words, race-based harassment or harassment based on age or harassment based, for example, on marital status, which is protected under New York law. So harassment is a form of discrimination. So there's no obvious reason why you have to have separate non-discrimination and anti-harassment policies. Many employers have a policy that combines the two concepts, recognizing that harassment is a form of discrimination. But for our purposes, we're at least looking at the fact that in New York, you have to have a sexual harassment policy. To what extent and in what manner are you going to address harassment based on all the other protected characteristics? Arising out of the employment discrimination laws, there are also issues related to reasonable accommodations. This relates to disability, most notably, but also to religious beliefs and specifically under new state and federal laws or newer state and federal laws also relate to pregnancy-related conditions. So some employers have specific reasonable accommodation policies, which might say we make our best effort to accommodate these types of issues unless there's an undue hardship. And if you need an accommodation, here's who you talk to, or here's where you submit your request, etc. Again, there's no formal obligation that you have a reasonable accommodation policy in writing, but they are certainly common enough. And again, whether you include it as part of one of these other policies or as a standalone component of your handbook is not necessarily critical. Finally, we have affirmative action. I want to point this out, especially because some of you will have been aware of the recent Supreme Court decision that, in essence, struck affirmative action from college admissions. As you could be aware, that doesn't specifically say anything about the employment context, but it is a commentary on the legality of affirmative action, I suppose. What I'm really referring to here is affirmative action and affirmative action policies that are required for certain employers that are government contractors. If you have sufficiently large government contracts that you are required to have a written affirmative action plan and affirmative action policies, then hopefully you're familiar with that. And on top of those obligations, in that case, though, affirmative action does not mean we're going to hire people of one sex over people of another sex, or people of one race over people of another race. The type of affirmative action that legally permitted there really pertains more to activities to, one, understanding the extent to which your workforce is reflective of the general public or the people that might be available to work for you, and then taking actions to make sure you're recruiting from the right pool and the right sources so that you don't, even if unintentionally, discriminate against or reduce your chances of hiring people from certain protected classes. So in any case, if you had a policy that flat out said we're only going to hire men for this job or women for this job or people of one race versus another, it's almost a per se instance of discrimination. There is a possibility you could have a bona fide operational qualification for that type of distinction, but it's very rare that those are accepted, especially these days. So anyway, we have all these types of policies you might have addressed. Again, you can combine them in certain ways or not. So here are some of the considerations into how you want to handle this area of policy making for your company. First of all, you have to have a sexual harassment policy if you have at least one employee in New York. So we know you have to have a sexual harassment policy. You presumably want to at least base that off of the New York State model policy. If you've already done that, then you're going to want to review the new model policy and decide what changes, if any, to make. The next question is how many, meaning how many different policies. And actually on this real quick, I want to throw up this poll to just ask, to the extent you know, what does your company do now? Do you have just a sexual harassment prevention policy and no other harassment policies? Or do you have separate policies for sexual harassment and others? Or do you have just a general anti-harassment policy that just includes sexual harassment, which would have been more typical before the state specifically required sexual harassment policies? This is anonymous, so if the case is you don't have a written anti-harassment policy, even though that might be against New York law, you can indicate that. I won't be able to know who you are. Right now, it looks like an even combination of we have just a sexual harassment policy, we have a combined policy, and we have one policy on sexual harassment and one on others. And that doesn't entirely surprise me. I think all are permissible. There are schools of thought both ways. Some people think you have to have a separate sexual harassment policy. Some people think best practice is to combine them. I try to be as practical as possible when I'm helping employers think this through and put this together, starting with what do you have now and then what we're going to do going forward. There is some practical value to having a separate sexual harassment policy because that at least makes it easier to show that you're compliant with the New York State requirement. And there's a couple of other pieces of that we're going to end up talking about before we're done. Okay, so I think that's a case-by-case analysis. I don't have a best practice to suggest you have to do it one way or the other. And I don't know that the state in any way has suggested you have to do it one way or the other. I know they've added the language to other forms of protected characteristics in the sexual harassment policy, although I doubt they would intend that to mean you can't say more somehow about other forms of harassment. So I think you have leeway as long as you think through the ramifications. So yeah, what to include in these policies? Again, technically the law says have a sexual harassment policy. You don't have to put anything else in writing unless you're a government contractor or subject to some other, contractual obligation. Even private contractors will sometimes require that their vendors or customers or suppliers or what have you have specific policies. So that is a possibility. But without that, I think generally you're going to want to have written statements saying we don't discriminate, we don't condone harassment. And if you have concerns about these, then bring them to our attention. If they're brought to our attention, you shouldn't be retaliated against. But again, whether that's 3 policies or 1 policy can depend on the circumstances. Where do your employees work? Now, there are 2 ways to look at this. One could be literally what type of work environment. So some employees, it might make more sense to have longer and more extensive policies. As I mentioned, the New York State model policy is 11 full pages long, actually goes on to a 12th page, but just barely. I don't know how many employees in most workplaces are going to read an 11-page policy. I guess it's there if they really need to. But that is something of a factor. But what I'm really more focused on here is geographically. Do you only have employees who work in New York City? In which case you could tailor your policies more specifically to the New York City human rights law, which if you're satisfying the New York City human rights law, for the most part, you're not going to have any trouble satisfying the New York State human rights law. If you have employees who work in all 50 states, on the other hand, there are other states that have different specific protected characteristics than New York and different requirements on whether you have to have a sexual harassment policy in some cases and what that policy has to include. So you may want to have a general statement of policy on discrimination and harassment and then supplements for specific states. For example, if you have employees in New York and you have employees in California and you have employees in other states that don't have as stringent anti-harassment laws and sexual harassment policy requirements, then you may want to have a more general policy and then give the employees in New York the New York supplement that satisfies New York law and give employees in California the California-based supplement. And those are just examples. There might be a couple of other states where you would want to have a supplement as well. If idiosyncratically you only have employees in New York and Texas, then keep in mind that the laws in New York and Texas are going to vary pretty significantly. So again, do you want to give everyone that works in Texas what you have to give employees in New York? Another question is, do policies make a difference? And here I refer back to the change in the New York State law that basically says it doesn't matter if you had a complaint procedure because it doesn't matter whether employees complained. If they're harassed, then they're harassed and you are liable for harassment that meets the reduced state standard. But that being said, certainly policies make some difference, if for no other reason than they're good evidence to have when you face a claim. You're better off being able to say, look, we had this carefully thought out policy in place than trying to show up and say, well, there's not a law that specifically allowed us to use this as a defense, so we didn't bother putting a policy in place anyway to prohibit discrimination. You'd rather have something, and of course, I mean more than sexual harassment. Obviously, you have to have sexual harassment. When you get a complaint of sexual harassment filed against your company with the Division of Human Rights, they're pretty much automatically going to ask you for your sexual harassment policy and for records related to your sexual harassment training, which is what I'm going to touch on in just a moment. Because they ask for that, that is one consideration in what do you want to do by combining policies, having separate standalone policies, etc. If they're going to ask you for your sexual harassment policy, there's an argument to be had that, well, maybe it would be good just to have a sexual harassment policy that we can provide and also have a different policy that we don't necessarily have to provide because maybe we don't want to complicate the issue more than showing that we met the state requirements. And for that matter, maybe you don't want to address every other form of protected characteristic in the same way that you're statutorily required to address sexual harassment. But assuming you are going to have a standalone anti-harassment policy or a sexual harassment policy that also addresses other forms of protected characteristics, the basic points you want to make are that you prohibit unlawful harassment unequivocally. I wouldn't, unless you have to for the sexual harassment piece or you're trying to combine them, focus too narrowly on legal standards. You don't want your policy to just say if it's illegal, it's against company policy. Ideally, you want there to be things that are not technically illegal, but are still things that your company doesn't condone, because it would be nice to be putting a stop to inappropriate behavior before it reaches the level of unlawfulness. Obviously, you want to include the protected characteristics. If you are in 30 states and you're having a catch-all policy, you may not want to try to cover all of the protected characteristics. You may just want to cover the federally protected characteristics and then state that, you'll also prohibit discrimination and harassment based on any other characteristic, protected by applicable law. Like I said, in some states, you may need a supplement. You want to use examples, you have to in the sexual harassment policy. Those examples in the model policy are limited to sexual harassment. You should probably include in a more general anti-harassment policy some other examples. Certainly you want to address reporting and investigation. It probably is easier to use the same process for sexual harassment and other forms of harassment. Again, you're not strictly required to do that. You want to, in connection with that, identify key contacts. Do we go to human resources? Do we go to a particular person in human resources? Usually you want to leave some flexibility. You can't just require somebody to contact their supervisor without somewhere else to go, out of risk that their supervisor could be the one they feel is harassing them. And a final important note on these policies is that a lot of you want to have zero tolerance policies, but don't necessarily either understand what that means or mean the same thing as other people. So zero tolerance doesn't have to mean automatic termination. What it should mean, to the extent you want to use the phrase or generally apply the concept, is that we don't tolerate harassment. Doesn't mean that you're going to automatically lose your job if you engage in harassment. Just we're going to take it seriously and take some sort of appropriate corrective action. Theoretically, you could have a policy that anyone who engages in harassment has to be fired automatically. But even the New York State model sexual harassment policy doesn't envision that and has language that allows that the right response could be counseling, training, or potentially suspension or termination. Finally, we're up on our hour. Just bear with me for another moment. If you have any questions, make sure to get those in. I just want to mention again the training requirement in addition to the sexual harassment policy requirement. The laws took effect in 2018, requiring annual training by October 9th of 2019. Again, that was not a one-time thing. That is every year. What the year is, you have some flexibility. It could be calendar year, it could be employee anniversary date, or it could be something else, as long as somehow or another it's a year. So for example, if you did your first training on October 9th and want to then make sure you do training every year by October 9th, then that could be the year you use. I think probably calendar year is the simplest, but you have some discretion. There's no specific time period for training new employees, but you do have to give new employees a copy of your sexual harassment policy at a minimum. And the state encourages training as well as soon as possible. I want to point out New York City has online training that you can have your employees complete that would satisfy the New York State requirements, with the caveat that New York State just updated all of its training materials. They have model training materials. I don't think the New York City training program has been updated based on the new model state sexual harassment policy. When you do this training each year, and if at the beginning of employment or other times, you have to give employees a copy of the sexual harassment prevention policy at each training session, which in essence means that you have to redistribute your sexual harassment prevention policy annually. So if you haven't updated it based on the new model policy, or there's now something you want to update based on something you heard in this presentation, maybe the first question to ask is, have we done our training yet this year? If not, that might be the time to change out your policy, because you're going to have to give it to employees at that point too. There is the model training materials. They have been updated online. There's even videos that you could have employees listen to. Whatever you do, you have to give employees a written copy of the information. So if there's a PowerPoint, they need to get the slides. If there are handouts, worksheets, they have to get all of those in addition to the copy of the policy. My only other note there is there are foreign language versions of the training as well, and you do want to consider giving employees training in languages that they will understand at least, but only the English version so far has a new video training from New York State. The others are still the 2018 versions. So kind of in conclusion, I would just say policies are good. Training presumably is good. There is some concern if you're only focused on sexual harassment. Expanding the training and policies beyond sexual harassment at least more involves everyone. It somewhat reduces the possibility that the focus just ends up being men versus women. Obviously, there can be sexual harassment of all different varieties and angles of any genders, but it is possible that men feel more targeted in sexual harassment training than women. But if you do broader training, and again, there's no specific clarification whether you can meet your sexual harassment training requirement in a session that also addresses other forms of harassment. Clearly some reference to the other forms is going to be warranted and probably recommended anyway. So do generally suggest trying to expand so that everybody has a more ready chance of seeing themselves as a potential victim and or someone who could potentially say or do something that someone else would feel is harassing. overall, if you want real results here, the focus should be on changing behavior, not just checking off a box. If you're just doing the training and just having a policy because the state says so, then you're not really doing very much to prevent your legal liability. Of course, there is limited evidence yet on how effective training can be at preventing harassment, but it's probably the best preventative action you can take generally, other than trying to improve the management and supervision to catch any signs of harassment or inappropriate behavior before it gets too far. Certainly, supervisors can make a difference. The extent of resources you can allocate to helping them make a difference, varies from circumstance to circumstance. Some people are just going to do things they shouldn't have done. It's going to constitute harassment. You're not going to, no matter how good your managers are, they're not going to only hire people who will never engage in conduct that somebody else complains of. But the better they monitor what is going on in interactions, and the more respected they are, the people come to them and let them know what's going on, the better. Ultimately, no inappropriate conduct can be tolerated. Again, doesn't mean that everyone is going to lose their job instantly. Legally, there's a very thin line between harassment and lawful conduct, and you want your policies not to toe the line, but to make sure you're weeding out behavior that is getting close. Because again, with the new standards in New York, the goal really is not to address claims of harassment once they're made, but to do as much as you reasonably can to stop problematic behavior before it gets worse. So now I will answer any questions. I'm going to go ahead and put up the link to the slides. Thanks for sticking with us for a few minutes extra. So there you have the link to the slides. The only question I've seen so far is about an email address for where you're going to get your confirmation of attendance. I'll take care of that for the person who asked that. If you don't get an email by the end of tomorrow and you need it for your credit, then you can certainly reach out to me, and there's my contact information, but that should go out tomorrow. You'll also, again, get a link to the slides and be able to download them that way. I still don't see any questions. If you have a question, either go ahead and enter it or type something to let me know you're about to ask a question, and I will ask it. Otherwise, again, you probably want to be reviewing your sexual harassment policy and other harassment and discrimination policies at this point. The list of protected characteristics continues to change every so often, so that's something you may want to update as well. And then take a look at the new model policy to make some decisions on what you want to do with that. And then also take a look at the new state training materials. You don't have to use the state materials. I think it's probably more effective if you don't use the state materials, or at least sometimes you have other training methods, not just regurgitating the same state provided training every year. But you do definitely have options in that regard. So, yeah, that's a good question. Is the New York State video interactive? So yeah, the training has to be interactive. I didn't want to spend too much time on the training. This is mostly to get into the policy issues and the changes to the model policy. But the New York state provided materials actually identify on the website that if you just have employees watch the video, that's not alone enough to be interactive, but they do have suggestions on how you can make it interactive. You have a lot of leeway there. You don't have to have a live presenter. You don't have to have everybody in a room together. You can let somebody watch the video and then submit questions if they have them. Even if they don't actually submit questions, if you've allowed them to submit questions, then that counts as being interactive. If you have a quiz basically that you use after the video has been watched, there's that. And then the training materials do include some scenarios and slides on different examples you can use, and then ask people to comment on what they think about the different situations. That also would be a way to make it interactive. So you have pretty broad discretion, but it has to be more than just literally watch this video. But it doesn't have to necessarily be much more than watch this video, and then if you have any questions, email me. Yeah, so again, the video itself is just on YouTube. And if you just tell people watch the video, it's not enough. But you have different options on how you want to do it. The New York City program actually has built-in questions, and that does meet the New York State requirement according to both New York State and New York City. Like I said, it hasn't been updated as far as I understand based on the new model policy, but I don't think that's necessarily going to mean that the training is not effective at this point. That is sort of a click through that would qualify as interactive because it does require people to answer questions as they go through it. Okay, well, I don't see any more questions at this point. If you have one, let me know. Otherwise, I'm just going to give it another 20, 30 seconds here, and then I will log off. If you have any other questions offline, you can certainly contact me as well. Thanks, everyone, for attending today's presentation. Look forward to seeing you next time.